Hello and welcome. This short presentation outlines the pre-mediation process steps and comes from the Mediation Institute AMDRAS Certificate of Training course. Shows you an overview of the pre-mediation process. It's structured and flexible preparation phase that occurs before any joint mediation sessions. The structure that we're using is always to start with the mediator's opening statements to set the scene and establish rapport, then a brief section discussing with the participant the issues to gain mutual understanding of the issues. Then we move on to screening and process preparation. This is all about working out whether or not mediation is appropriate, if any modifications are needed, and if there's any other additional support or resources that are needed. After that, there comes the preparation for negotiation. Again, we'll be working through looking at the issues with the party and helping them to consider their options and prepare for the mediation. And then the final step is to summarise the progress that's been made, discuss the next steps, and they'll vary depending on what type of mediation and whether you're working with participant 1 or participant 2. And then that's the close of that session. As a nationally accredited mediator under AMDRAS, you've got some obligations. We need to determine the client's capacity to participate. We can't allow or facilitate a process that's coercive or inappropriate for the client's needs. We have to determine if the dispute is appropriate for mediation, and we support self-determination and appropriate conduct by confirming the client's understanding and agreement with the mediation process. Of course, we need to prepare clients for a collaborative negotiation style in mediation when we're looking at the facilitative mediation process. In the training, there is a practice session where you'll have the opportunity to work with other students and practice the pre-mediation process. The tools that you'll use will be an agreement to mediate as a guide for your opening statements and intake forms for your notes during the issue identification, risk and suitability screening, and preparation for mediation stages. And in that final summary where you talk with the client about any referrals that have been mentioned and additional steps. In the mediator's opening statement, some of the key information that you'll be sharing and confirming with the client is that their participation is voluntary. Mediators do need to check if the parties are attending willingly. They can't be forced to agree. We also need to explain confidentiality and the exceptions to confidentiality to make sure that clients understand how their information that they share may be used. And the other thing that we need to discuss is inadmissibility. So generally, anything that's discussed in mediation is inadmissible, which means it can't be used as evidence in court. And usually, if an agreement's reached and signed, it will be admissible, but generally it's not enforceable. We also want to make sure that they're very clear about the mediator's role. In this style of mediation, it's facilitative. You might be providing advice. You must be independent, and you should not have any conflict of interest. In this style of mediation, you definitely will not be providing advice. And we also need to define the party's role. That is to communicate respectfully and try to collaboratively negotiate, making sure that they listen to what the other person is sharing with them. And the final thing we need to do is to set some ground rules for the pre-mediation, which are usually around using first names and respectful language when they're talking about the other person. Okay, let's have a look at the understanding the issues stage. What we'll do is invite the party to explain the issues and why they're an issue for them. We want to frame this so setting clear expectations about a brief discussion. Try and have a little bit of guidance without stifling the party's ability to talk about what's important. We engage with them using open-ended questions that allow them to talk to us about what it is that's important, and we demonstrate active listening to check our understanding. asking clarifying questions, doing little summaries. What we're doing here, as well as giving the party an opportunity to identify the issues, we're looking at some of the potential causes of the conflict. Is there a lack of information that's driving misunderstandings and misinterpretations? Is it poor communication that's compounding a lack of trust and distrust? Are there values differences that we're hearing coming through? Are there social disparities? So is there some sort of culture difference that's driving the conflict? Are there structural inequalities? They are things that might be causing a competition for resources or power. And are there different interests? So are there goals that are competing or different expectations around what's important? We do want to keep it brief, but also remain facilitative and I suppose build up a little bit of a rapport bank for the next stage, which will be risk screening. Next, we'll move on to risk and suitability screening. We're looking at legal and safety considerations. Are there any personal safety orders, court orders in place that we need to discuss or understand? Before you get to pre-mediation, you should have found out about those and know whether or not mediation is able to proceed at all. Is there a history of broken agreements, non-compliance patterns or breaches of agreements? Is there a lack of voluntariness? And that might be external pressures, or it may be that the mediation's being used strategically as a delaying tactic. One of the critical things is has there been a history of violence, threats or coercion? So we want to know about instances or coercive tactics, and remember we need to ask the person we're speaking with and not just ask them about the other person. Is there substance abuse, mental health or other issues that may impact their ability to participate? The fact that someone has a mental health issue doesn't necessarily mean they can't participate in mediation, but if it's uncontrolled, it may mean that it's not appropriate for them. Is there third-party interference? So is there undue influence coming to the party? Is it going to mean that they're not able to reach agreement? Do they have the authority to reach agreement? And also, are there confidentiality risks? We're starting to talk a bit about their approach to the negotiation as well. So do they have unrealistic or not negotiable positions? Are they seeking punitive measures rather than a agreed outcome from the mediation? Is there a power imbalance or a history of hostility? Are there control dynamics, aggression? So all of these things are going to be factors that we take into account when we're determining whether or not mediation is going to be an appropriate process. And then we need to just make a decision about whether it's suitable for this case. Now, of course, sometimes that decision may be able to be made with the first person, sometimes not until we've met with the second person, and sometimes it's not until we see the dynamic when they come together. But we've got three options. We can proceed with the mediation in a standard approach, we can modify and make adjustments to address specific concerns, and they may be including support people, having lawyers available to assist, or another format. And if mediation is really just not considered appropriate, what are their next options? Is it a court or tribunal? Is it a legal intervention, a protection order or something with the police? So all of those are options for people. Okay, assuming that we've decided that the mediation is able to proceed or that we've worked out modifications, now it's time to prepare the person for mediation. Sometimes this part of the pre-mediation gets forgotten. People think it's just determining is it okay to proceed and then on to the next step. But this is really the opportunity to help people to understand the mediation process and consider their options and how they may be enabled to reach an agreement. So how do we do this preparation? We want to recap on the issues that they raised at the start of the pre-mediation session and some of the solutions they might have talked about. We may talk with them about what's been tried in the past. Are they other solutions that they're proposing, things that have been tried and failed in the past? Why would they work now? those sorts of questions. We may want to talk with them about the barriers to resolution. So what are the obstacles? What are there external factors preventing resolution? And if it's a structural type dispute, it may be that there are things outside their control, and that might be something that needs to have a discussion. Do they have the resources they need? So what resources or support might they need? Is it additional information that they need? They should have an understanding of what the alternatives are if the mediation fails. That might be something that you're going to talk about. And I've got a little picture of the BATNA and the WATNA down there. So the BATNA is the best alternative to a negotiated agreement. So that knowing their BATNA, knowing that if they can't reach agreement, what's the best outcome for them, that'll help prevent people being coerced into an agreement that's actually not in their interests or significantly worse than what they could achieve if they didn't agree. And likewise, the WATNA, the worst alternative to a negotiated agreement, that really helps people to look at the risks of not settling. So it encourages realistic expectations. It's common for people, if they don't understand their WATNA, to reject a fair offer, a reasonable compromise, and end up in a much worse situation. That middle ground is balancing the risk and reward for an acceptable outcome. The other model up there is ZOPA, the Zone of Possible Agreement. We're looking at the overlap between what one party is willing to accept for an agreement and what the other is willing to offer, where the overlap is between their best case and worst case scenario of what would still be within an acceptable range, is where that zone of possible agreement. Exploring the alternatives if the mediation fails. It can be helpful to explore the impact of resolution as well. If they can reach an agreement, what's going to be the benefits for them? How will that, and it may, if they're a person that's being driven by emotion, how will that make them feel knowing that they can end this conflict and not continue on in this way? Again, is there additional information or support services that you're able to connect with them with? The final thing is we want to help them to prepare for legal advice, and so we might be talking about questions that they may need to ask. Now, it depends on the situation. In many situations, it's a civil dispute. They may never end up in court unless someone resorts to violence, but it may be they need to get information from the local council if it's a dispute over trees and fences or things like that. So a little bit of an overview of preparation. Now, you may not need to discuss every single element with every single client, but having this idea really will help. Okay, so the final stage is summary and next steps. One of the things that we want to leave our clients with after the pre-mediation is clarity, so they know what to expect, what's coming next, what they need to do to prepare for the mediation. You're going to complete your individual discussions with a summary of what's been discussed, the issues. Maybe talk to them about, if you haven't already done so, about some dot points for their mediation opening statements. You want to discuss the process to schedule a mediation session, and that'll depend on whether it's party A, party B. You'll need to talk about payment. It's typical in mediation that people pay at each stage. So they pay for pre-mediation. Once it's confirmed that they're going to proceed, then they'd pay for the mediation session, and so on. You'll confirm the confidentiality, so remind them that you're not going to discuss what you've been talking about with them, with the other party. If you're in a situation where there needs to be an exchange of documents or information, that should be done in advance. There shouldn't be any ambushing on the day of the mediation. You'll confirm any referrals or any homework. So if there's information that they needed to get or other information they needed to provide to you, all of that you will be wanting to confirm. Of course, check if they've got any questions or concerns, and then confirm those next steps and close the session. Now, you may be thinking, wow, Joanne, that's a lot of repetition. But remember, usually our clients are going to be in quite a agitated, if not distressed state. People in conflict, it can be quite all-consuming. They may not be sleeping. They may be really struggling with the issues, and they're not necessarily taking things in as well as they might if they were in a less conflicted state. So repetition, making sure that they've understood, checking in, all of that is an important part of our role as a mediator, to make sure that people are as well prepared as they can be. That's going to really improve the chances that an effective resolution is going to be reached. Okay, so where to from here? If you're a student on our AMDRAS course, you'll be soon asked to participate in a practice session where you'll have a chance to observe and then act as the mediator and as a client in a pre-mediation session. If you're a Mediation Institute member and you've got questions about pre-mediation or intakes, group supervision is a great opportunity to ask questions, find out what your peers are doing, and so on. So go to mymembers.au and look at the events. There'll be a group supervision each month. If you have real concerns, you can book in for a paid supervision session with one of our team as well. So this is content from our AMDRAS Mediator Certificate of Training course, where we're including some practical training in pre-mediation as well as the mandatory requirements for mediation. So if you are interested in becoming a mediator, please visit our website to find out more. Even if you're not interested in being a mediator, but you're working in a role where you're having to facilitate discussions between people in conflict, such as in HR or management, you can do the course. You don't need to do the assessment program to become a nationally accredited mediator, but I'm sure you will find that there's some really useful skills and techniques that you'll be able to apply in other contexts.